Okay, we're now being recorded. I want to thank everyone who's joining us today. Today, our presentation is going to be on applications for letters of administration and determinations of heirship. It's being presented by Vanessa, and I'm going to let her introduce herself.
Great. Thank you so much, Lisa. Good afternoon, everyone. I'm so glad you can join us. As you can see, the topic today is they should have feared the reaper when people die without a will, applying for letters of administration with determination of heirship. As Lisa mentioned, my name is Vanessa Meduja, and I will be presenting on behalf of the Houston Volunteer Lawyers, which is a service of the Houston Bar Association. So who am I? As I mentioned, my name is Vanessa J. Meduja, Solis Meduja. I am a 2004 graduate of South Texas College of Law. I was licensed in 2005. I'm the senior associate attorney at Walden and Schneider. My areas of practice include probate, guardianship, and family law. So I do a little bit of everything if I can try to go ahead and work in various areas. I have found, however, that there's a little bit of family law in almost all my other subjects as well. Okay, so to get things started, these are some of the answers to the general questions that are normally asked during a CLE. First of all, questions will be taken and answered during the presentation, as Lisa had mentioned earlier. So please type your questions in the question and answer section or in the chat. Here is the CLE information. So that's the CLE code for live, and then the CLE code for the portion that's recorded, which will be available on June 17th. I will present my contact information at the end of the presentation, and I will reiterate the CLE information in case people show in midstream. It'll be shared again at the end. All right, so some general information. If you volunteer for the Houston Volunteer Lawyers Association, this is what they're going to get for you if it's an heirship determination. HVL will determine if the cases are eligible for an heirship administration. They take the intake information, they get all the information. They will explore all other probate options first. So they'll look at, amendment of title, small estates affidavits, any other options before they come to an heirship administration. So it's my understanding that if you have to do an heirship administration, all other options have been explored, and this is the last option. Only agreed to or uncontested cases will be accepted by HVL. So what does that mean? And obviously, we're lawyers. We know contest versus uncontested. But for an heirship administration type situation, all the heirs, depending on how many they are, hopefully it's just the spouse or maybe deceased widow with children, they're all in agreement. They're on agreement as to who all the heirs are. There's not an unknown heir. There's not a black sheep individual out there somewhere that decides to come in. So everyone's in agreement. These are the heirs to the estate. We're all in agreement. And we're on agreement that it's going to be an independent administration. You can have an independent administration and you can have a dependent administration. Houston Volunteer Lawyers will only accept cases where it's an independent administration. That means without court authority. As if someone had died with the last will and testament, there was an executor appointed and they get letters of testamentary. There's no court monitoring or court involvement. Dependent administration is where the parties cannot agree as to who the administrator will be. The court has to appoint somebody to be dependent, and then you need to get court authorization and court approval and court authority to do everything. As I mentioned earlier, HVL will collect all the initial information regarding the client and the case. So they'll be handing you that information. Forms for an heirship administration is available via HVL. I understand they have a data bank of forms that they'll be able to direct you to and provide to you. So you'll have the forms necessary for an heirship administration. And all clients of HVL qualify for inability to pay fees. So like filing fees, cost expenses, they're either going to be waived or they're going to be reduced. And it's my understanding HVL will provide y'all that information when you receive the case in question. Okay, so let's start with some statutes that we're going to reference. So the first one is Texas State Code Section 202, which is the determination of heirship statute. That's going to help you work your way through an heirship and go to for guidance. The Texas Estates Code Section 301 is your applications for letters testamentary or of administration. So 301 covers both subjects, testamentary or administration. If you hear the word personal representative, that's referring to either an executor, executrix, or an administrator, or an individual that's an administrator. So there's multiple words there that can kind of be flipped. Texas Estates Code 303 is your citation and notice in opening up an administration. 304 is a person who can serve as a personal representative, and that covers both under testamentary and administration. 305 is the qualification of a personal representative, and again, that qualifies under executorships or administrations. More statutes. 306 is the granting and issuing of letters, and again, that's also for administration or testamentary. 309, inventory appraisements and list of claims. 401 is the creation in an intestate estate by agreement. So this is where your heirs have to agree to create an intestate administration. 401 is the means of establishing distributee's consent. Once you've established who your heirs are, you got to get them to get consent to everything. So that helps go into it. And then, of course, many, many more statutes. The Estates Code has statutes throughout that either address administrations or executorships. And so just be mindful of the fact that these are just not all the limited statutes, that there's many, many more to go. When do you request a determination of heirship? Okay, so how does a person know to do an heirship? How do they know that this is an heirship case? Well, one, when a person dies intestate, meaning they have no will, right? So they've passed away, nobody can find a last will and testament, nobody ever drafted something, so they die intestate without a will. There has been a will admitted into probate in the state or somewhere else, and an administration of the decedent's estate is necessary, okay? Because there was property in the state that was omitted from the will or the administration, or there was no final disposition of property in the state that has been made into the administration, or when a will states all of my heirs, but fails to identify those heirs. So many times people will prepare last will and testaments and say, you know, to my spouse, if my spouse doesn't survive me, to my children, if my children don't survive me, to all my heirs at law, right? So spouse predeceases, children predecease for some reason, and all we have are now all my heirs at law. Well, who are the heirs at law? So that's where you would want to do an heirship request or a determination of heirship to determine who all my heirs at laws are, okay? Another way is when you have a trust. So let's say somebody has a trust, it's a revocable trust, husband, wife. Husband dies, wife is still alive, so it's still revocable upon her lifetime. She passes away, it becomes irrevocable. And then all of a sudden in there is to all my beneficiaries, right? We don't specifically list beneficiaries or we don't list the heirs. And so in a trust that may not have to go through the realm of probate, you would have to do an heirship determination, okay? Determine who those heirs are to that trust. When do you request letters of administration? So the letters of administration through the Houston Volunteer Lawyers is done when there are no other probate options, right? They're going to explore all the other possible probate means before you get to letters of administration. So if they say, you know what, there is none, we got to do letters of administration. When a third party requests them, right? So mom passes away, daughter goes to the bank and says, hey, here's my mom's death certificate. She's passed away. I need to get to her bank account. Bank looks up the account and says, oh, we're sorry for her passing, but you're not on the account. You're not a beneficiary. We need letters from the court. We need either letters of administration, letters testamentary, or something to that effect, okay? So it looks like HVL put something on the chat about a great intestate chart. So that's really good. So if you haven't had a chance to look at the chat, go ahead and do so. A lot of courts will have a chart similar to this that will give you your intestate chart as well as the percentages. So that's a really great tool to have. Okay. So again, the financial institution. So, or maybe an insurance policy or an investment account, retirement, person passes away, sibling, spouse, whoever, child reaches out and says, they passed away, here's their death certificate. You know, we're sorry for your loss, says the third party financial institution, but you have no authority, get us something. Get us a court order, get us letters of administration, something to that. When real property is involved in the name of the decedent, whether it be individually or joint with others, most of this time, this request will come from underwriters when you go to sell property, okay? We have found that underwriters are very, very picky for a lot of things. And so if there is a house that's to be sold, underwriters prefer some sort of letters of administration. Oh, and really quick, a shout out to my 8-year-old son. If the slides are really cool and you like them, they were his doing. But if they're boring, they were my doing. He wanted me to tell you that. So letters of testamentary versus letters of administration. So letters testamentary are typically received when there's a last will and testament that lists an executor and all the other requirements are met, right? So you have a will, you probate the will, you have an individual listed as an executor, and you get your letters testamentary. Letters of administration happens when a person dies intestate with no will, and the person does not list an executor, or the will does not list an executor, or all the executors are unable to serve. So statute of limitations on heirship, very, very important, obviously. A proceeding to declare heirship for decedent may be brought at any time after the decedent's death. So let's say decedent died 10 years ago, and I actually have this case pending right now. I had a decedent who died 10 years ago. At the time of his death, he did not have any property, no real estate, everything was payable upon death beneficiary, nothing to that effect. Well, he, in the late 90s, early 2000s, signed up for a Roundup lawsuit. And so we're needing to declare who his heirs are to this Roundup lawsuit that's 10 years down the road. So I could go into court to ask for an heirship determination to determine who all my heirs are. Now that's for an heirship. If you want to tie that into anything else, then pursuant to Civil Practice and Remedies Code, if there's not an express limit period, then the statute of limitations is no later than 4 years after the date the cause of action accrues. So if you're looking at doing just an heirship determination, all we want to know who the heirs are, nothing else, and what their percentages are, then there's not a statute of limitations. But if you want to do an administration with your heirship, you have 4 years from the date of death to file and get letters of administration. If you're outside the 4-year deadline, you need to try to explore possibly maybe amendment of title or another avenue. But again, HVL would have screened that for you. And it's my understanding that if it's beyond the statute of limitations, HVL will not accept that case. And Lisa can correct me if I am wrong on that. So two-step process, right? The first step, and you have to do a determination of heirship. So the first step is you got to do your determining heirship to determine who all your known and unknown heirs are. Okay, you can't have an administration without knowing who your heirs are, because your heirs are going to have to agree to your administration. So your first step is the heirship. Once you identify the heirs, then obviously you're going to identify what the respective shares and interest is in either the estate or possibly even the trust. And Lisa did just confirm for me that HVL does screen cases and that statute of limitations is something that they look into. So once you do your heirship, then your second step is an application for letters of administration, right? And your letters of administration happen when all your heirs, so you determine who all your heirs are, widowed spouse, children, stepchildren, whatever the case may be, brothers, sisters, if there's no spouse or no children. And once all the heirs are determined, then all your heirs will agree who the administrator will be and that that administrator will be independent. Okay? If you have an heir that will not agree to an independent administration, then it will be a dependent administration if the heirs cannot agree. And again, it's my understanding HVL screens that very well to ensure that there's very limited heirs that will have a disagreement.
I just want to pipe up and say that we try to the best of our ability. I know that sometimes we ask people and they say they're in agreement. If you, for any reason, you take a case and it turns out not to be the case, please contact us.
Thank you, Lisa. So one application or two. That's a choice to make. Fortunately for everybody that takes a case with HVL, they have it as two separate applications. So you have an application for determination of heirship or an application to declare heirship, and then you would file an application for letters of administration. You can file the documents both at the same time. If you prefer to do your heirship first and get the heirship out of the way and then come back and file your letters of administration, you can do that as well. But I have found that if you just get everything filed all at once, you can get everything heard all at once. If you decide to take a case on your own after HVL, you can actually combine your applications. I do that. I have one application. My application says application to declare heirship and request for letters of administration. So that way it's just one document. Practice hint, as I mentioned, HVL clients, they have the inability to pay waiver, so they don't get charged when you do a filing. However, in private practice, if you decide to file two separate apps, you're going to pay two separate filing fees because an application to declare heirship is one app and an application for letter of administration is two. If you combine your applications, you only have to pay the one filing fee. Just a practice. So what needs to be filed initially? Okay, so the first thing you do with your determination of heirship, your application for heirship, obviously is your application to determine heirship or declare heirship. You got to do your affidavit of your applicant. Okay, so your applicant needs to go ahead and prepare your affidavit for your applicant, and your applicant signs that affidavit. Waivers. This is an ongoing debate among the probate bar. I'm a family lawyer as well. So in family law, you cannot have the respondent sign a waiver until your petition's been filed. So in family law, you filed your petition for divorce or custody or whatever petition you want. You present a file stamp copy of that to your respondent with the waiver. In family law, if the waiver is signed before a petition is filed, the waiver is invalid. That does not hold true in probate court. So a lot of people will get the heirs or the potential heirs or the potential distributees to sign a waiver ahead of time, and then you can file the waiver with your application. It's up to people. To reconcile it, I just wait for my waivers because the family law part of me is like there's something wrong with that process. It's not wrong, but that's just my thinking. So I always file my application to determine heirship first. Once I get a file stamp copy, I present that to the potential heirs with their waiver. Again, it's up to what you feel comfortable doing. You file also your motion and order on appointment of attorney ad litem. You do not need to get a hearing date on your motion and your order. If you initially file it with the court, it's part of your process and the court will then eventually sign your order. And of course, all this is done electronically via the cloud through e-filing. Everything has to be done electronically. If you have an individual that they, for some reason, don't have access to the internet, they can do it through the district clerk's office or the county clerk's office, but everything gets filed electronically.
Vanessa, there's a question about what they're waiving.
Oh, okay. I'm sorry. So the waiver for the airship is basically them saying that they understand that they are a potential heir in the airship. So I'm John Smith. I understand that I'm a potential heir. I understand that I'm entitled to get something out of this estate, and I hereby waive the right to be served with notice to appear in court in the future. It's basically their consent for the case to continue on without them having to be personally served, and give notice of potential future filing. So if you have a hearing for your airship, you do not have to give notice to those heirs that signed the waiver that you have a hearing. If they refuse to sign the waiver, then you have to physically get them served, right? And now they're a party to the lawsuit, and you have to provide them notice if they file an answer, and you have to give them so much time for a hearing and stuff to that effect. Okay. If I didn't answer your question, let me know and I can clarify that further. Go forward. Oops. I don't know if my screen froze.
I'm still seeing the same
Yeah,
screen.
I'm still saying the same screen and I don't know why. Oh, there it goes. Okay. So what all needs to be filed initially, this is for the independent administration portion. Obviously, your application for letters of independent administration, affidavit of your client, and the affidavit for both basically says that your client has read the document filed, everything is true and correct to the best of the knowledge. They don't have to go into facts or specifics, just I'm the applicant, I've read the form, the document that's to be filed, everything stated is true and correct. If there's something that they've omitted in the applications, they have to state in the affidavit what they've omitted and why they've omitted that information. Again, waivers. Now this waiver is for your heirs, so your potential heirs. Granted, at this point, they've not been declared heirs, or maybe they have, but your potential heirs acknowledge that your applicant is looking for letters of independent administration and that they do not object to that person being appointed as the independent administrator, and that they waive their right to appear or get notice for future appearances.
There is a question about how service is done. Does it have to be personal service or can it be certified mail?
It can be certified mail. So you can do service by personal, or you can do service by certified mail, and you can request the certified mail service through the county clerk's office, or you can do it yourself. Obviously, if you request it through the county clerk's office, then when the county clerk receives the green card back or the mail that was rejected, they will automatically file that for you. If you do it yourself by certified mail, then when you receive your green card back, or when you receive the mailing that was rejected, you got to scan that in and get that filed so that the court can see that service was done one way or the other. So you could do it either way, by personal or by certified mail.
And there's another question that talks about heirs with unknown locations. In an HVL case, that wouldn't be the case, but I'll let you get on, because I know that there's always the ad litem appointed for the unknown heirs, even if there aren't any unknown heirs. It's a requirement.
Right, and it's also a requirement for posting. So that's what I'm going to get ready to discuss next, is what's to request in your initial filing. So for an heirship, so you file your documents. Okay, so you tell your paralegal or yourself, okay, I got to go to e-filing. I'm going to file my documents. You've attached your documents. Now you're in the fee section. What do I need to pay for? What do I need to request? So you got to request posting, okay? And this, or it's also called citation by publication. It varies from county to county. In Harris County, I believe it's referred to as posting. Service, citation or service on the heirs, maybe. This is if they don't sign a waiver, or you only have, if you have widowed spouse, you're not going to serve widowed spouse. And because she doesn't have to sign a waiver because she's made an appearance through the application. But as I mentioned, citation can either be in person or it could be by certified mail through the county clerk's office or through your office if that's what you wish to do. If there are unknown errors, okay, then you got to do another citation by publication. The posting and the citation by publication is for your application. So when you file your application, you've got to request posting or citation by publication on the application itself. And then if you have some unknown errors out there, then you've got to do another citation by publication for those unknown errors, which will trigger the appointment of attorney ad litem if one's not specifically requested. For your administration, again, you got to post citation by publication. So this is where combining would be beneficial because then you're not paying two separate fees. You can just basically do one document for one posting, one citation publication. Again, if you have errors that you got to serve, you're going to have to serve them twice. If you file the documents separate, you got to serve them with an application to determine heirship and an application for administration. But if you combine the documents, then you do one service per person per document.
There is a comment in the chat that said civil process rules require the certified mail return receipt requested to be signed by the recipient, and that over COVID, he's only seen one green card signed. The post office quit doing return receipt requested during the pandemic. Yes, you're correct. They quit doing it. So just be aware. I don't know when that's going to change and when the post office is actually going to start getting signatures again. But that is a practical tip. And thanks for pointing that out, Brian.
Thank you so much. Okay, so now your pleadings have been filed, right? So everything's been filed, nothing's been rejected, or it's got rejected from the clerk's office because they're extremely picky, but you've rectified the rejection and you've got your approval. And so what happens? Okay, so your case has been approved. Obviously, you're going to get your cause number and your court number that's been assigned to when you get your notice of approval or acceptance. Great practice hint. Go to that court's website, whether it's 1, 2, 3, or 4, because the judges there have some awesome information as to what their particular procedures are. Every court is different. Every judge has a different procedure, different policy. So spend some time, get to familiarize yourself with the court's policies and procedures. Their information is available on the website. If you file separately, so you decide to file, okay, I file my heirship and my administration separately, and somehow they end up in 2 different courts, just call the clerk's office and just say, hey, I've got 2 different cause numbers, same type of case or same estate, can we combine them? And it's going to get combined into the court that had the first filing. So if one gets filed at 10:01 and one gets filed at 10:03, then it's going to fall into the court that got filed at 10:01. If you have properly requested posting citation, you'll get a return date. So when you get your approval notice, you should see in your approval notice the cause number, the court number, and what your return date is. If you don't receive a return date, you forgot to request posting or you didn't do it correctly. And if so you don't get it, call the clerk's office or the court and say, I filed this, I don't have a return date, what did I do wrong? Return date is the date that the post is returned and filed with the court. It's typically 14 days. And it's been a long time since I've had to calculate it, but I want to say the return date changes every Wednesday. So you count 14 days and then every Wednesday, just count 14 days from that Wednesday. If it's not a Wednesday, it's a Monday. But you just count and you can kind of get an idea of when your return date would be. Other practice hints is the Harris County, they post in the daily court review for you if you properly request to do so. Some counties will not post for you. They'll prepare the posting, send it to you, and then you have to go make contact with the newspaper of whatever that county circulates in and request the posting that way. And again, either the newspaper will file it with the clerk's office when they've done running it, or they'll return it to you and then you have to file it with the clerk's office. Just check with that newspaper when you find out which one it is, and they'll tell you what they particularly care for. Or if you have an awesome paralegal like mine, she takes care of it all and I don't have to worry about it. So what else does the posting date do? As I mentioned, it's 14 days long from the date of filing to its date of its return. Once you get your posting date, so you file today, it gets accepted to, well, today's Friday, so it gets accepted Monday, you get your posting date. You can set your hearing for any time after that date of posting. You can't have it heard before, but you can have it heard after that date. So now you kind of have an idea, when can I have this heard? That is typically when the court will appoint your attorney ad litem. I'm not familiar of many courts that appoint your AAL before your 14-day posting date has expired. Many of them wait till after that date.
Hi, Vanessa. There's a question about when you're required to post through the state registry, and I'm not familiar with that.
I'm not familiar with the state, and when they say the state registry, I'm not quite sure what they're asking. So if they can expand on that state registry.
If you don't mind putting a little more details, Suzanne, we can follow up. Thanks. I'll let you know when there's more.
Okay, great, thank you. Check the court's online records to see if the court has appointed your AAL. I don't know what everyone's experience date range is, but if you go to the Harris County Clerk's website and kind of scroll down in the middle, you're going to see where you can search records. It's got a little magnifying glass, and then you click on that, and it gives you like real estate, marriage license, probate. Click on probate. There's a window there that you can enter into your case number. You click on that, and it's going to give you all your filings. Okay. So after your 14-day posting date, go ahead and look online to see what the online record filing system shows to see if your AAL is appointed. Sometimes, not always, some courts are courteous enough to email you and say, here is the order on appointment of AAL, and they've copied your AAL for you. Some don't, right? So just constantly tickle your online filing system, see where your AAL is appointed, because as I said, sometimes the courts let you know and they don't. If after 30 days from filing, so you've let the first 14 days go, you got like another 16 days or so, if after 30 days of your filing, you don't see your AAL appointment or you've not received notice, just email the court or have your paralegal email the court and say, hey, this is the cause number. We filed this point. We haven't seen our AAL being appointed. Can you let us know? Keep in mind, I think the majority of the courts are still working remotely, so they're not as fast as they used to be when they were in person. So it could just take a little quick reminder from you to them for them to be like, oh my gosh, we forgot to do that. Let's get that taken care of. All right, so your attorney ad litem is appointed. You got notice somehow or another that this is the person that's going to be your AAL. What do you do? Once you get notice of appointment, reach out to your AAL. Okay.
There was I apologize for interrupting, Vanessa. There was a clarification about how to publish in the newspaper. It's my understanding that you said that Harris County sends it directly to the Daily Court Review for you.
Mm-hmm.
And then the Daily Court Review will send you a bill. And I know that Vanessa is going to say this later on, but HVL clients get a 50% off. They don't know that till you tell them. So when you get the bill, you just say, hey, HVL client, and they go, okay, pay 50%. And for other counties, you might have to take it to the newspaper yourself. Is that correct? Okay.
Yes.
Sorry, I'm afraid to say for other counties. I'd like you to confirm. I apologize before I type it.
No. So just to give you an idea, like Montgomery County has a form. So they have a form that they want you to fill out, and then you send that form to the newspaper. And then the newspaper will go ahead and prepare their language that they use to run in the paper.
Do you know which newspapers you can use in other counties? Because the Daily Court Review is very affordable as well.
Yeah, I just had a case in Montgomery County, so I don't know what paper we use. I know in Galveston, it's the Galveston News, Daily News. I think it's down in Galveston. When I get a new county, I just have my paralegal call the clerk's office and say, hey, we got to run something in the county newspaper. What newspaper does the courts prefer? And they'll tell you. And then you can reach out to that newspaper and then talk to their advertisement or legal department. And then they'll give you the information to tell you what they prefer as well.
That's a good tip. Thank you.
You're welcome. Okay, so you get notice of your AAL, reach out to your AAL. Some courts will give you name and phone number. Some courts will give you name, phone number, and email. So if you get a name and a number, then you can either call or go to texasbar.com, do attorney search, and then you can get their contact information that way as well. Right? So you're going to reach out to your AAL. What information do you provide to your attorney ad litem? Okay, copy of the order of appointment. Sometimes the court lets them know they're appointed, sometimes they're not. There's many times I've reached out to an AAL and they're like, oh, that's news to me that I was appointed. Okay, can you send me my order of appointment? So just courtesy, send them the order of appointment. Send them the pleadings filed. Yes, it's a matter of public record. And yes, your attorney ad litem can go online and look up the records themselves, but we want to keep our attorney ad litem happy. We want to make things as easy for them as possible. So please be courteous enough to send them that information. Provide them your name, telephone number, and address of your two disinterested witnesses. This is information that you should be getting from your client, hopefully up front, or maybe HVL gets you this information. But you're going to need the name and numbers of two disinterested witnesses for the heirship. And let me just clarify, the attorney ad litem is only for your heirship portion of the probate, not the administration portion. Contact information for the client in case the AAL wants to speak to your client. I have found that some AALs will speak to the client. I have found that some will not speak to the client, but just provide them that information, let them make that determination. Funeral announcements or obituaries. I have been finding a lot of my AALs have been asking me for this information. So if you can get it from your client ahead of time. And the purpose of that is because when people make funeral announcements or list the obituary, they tend to list family members. So if your client says, oh yeah, they died and only had one sibling, or one child, but the funeral announcement mentions a second child, there's something going on there. So if you have it, if it's available, provide it to your attorney ad litem. Birth certificates, marriage license, divorce documents. Some attorney ad litems ask for this, some do not. If you want to get it from your client upfront, you can. If you just want to give your client hey, the ad litem may ask you for this document, be prepared to provide it at some point in the future so they can gather it and have it ready. You can do that as well. So what does the attorney ad litem do? So your attorney ad litem is now appointed. What does the attorney ad litem do? They contact your two disinterested witnesses and they confirm with them who the heirs are. Now, your two disinterested witnesses ideally should be somebody who has been in the family for a long period of time. It could be the next door neighbors. It could be the pastor. It could be a professional accountant, CPA, a bank manager. It can also be family members that are not entitled to inherit. So let's say that the only heir is widowed spouse, or maybe the two children that spouse parents have predeceased and it's just the two children that are left. You can do uncle, you can do cousin, you can do aunt, niece, nephew, twin brother of the decedent or twin sister of the decedent. As long as they're not entitled to directly inherit at this juncture, they can be your two disinterested witnesses. Okay, don't do Bob, Joe, Bill, who's been at the bar with dad and they drink every Friday. Okay, try to make them credit. Now, if that's all you have, that's all you have. But we want some credible witnesses. As I mentioned earlier, sometimes the attorney ad litems may contact the applicants or the heirs. Sometimes they won't. So just let your client know they may contact you. They may not contact you. If they don't contact you or your heirs, don't take it personally. That's not really their job. Their job is to discuss with the two disinterested witnesses the heirship portion of the case. And to advise you when they're ready to proceed. So the AAL will come to you and say, I'm done. I've done everything I need to do. I'm ready to get this set for hearing. Let's go. Okay, so wait for your AAL before you start setting hearing dates. They may or may not prepare final report to be filed with the court. I have found that the newer licensed attorneys, they're gung-ho and they want to do everything perfectly and correct, and they're going to file their reports. And I have found seasoned attorneys that have been doing this for 20, 30 years and report? What report? I don't need a report. And so may or may not file a report. If you have not heard from your AAL 45 days into their appointment, okay, so you've made initial contact, you've provided them information, 45 days or so goes by, you've not heard, reach out to your AAL. Okay, keep in mind that your AAL is also a licensed attorney like you are. They have their own docket, they have their own cases, they probably have multiple appointments. So they just might be inundated or they just might be behind on stuff. Just, quick little email, hey, I'm just checking in, see if you need any help, do you need any information? Let me know when you're ready to finalize. Okay, so just courtesy, reach out to your AAL. Remember, they're lawyers just like you. All right, so what do you do while the attorney ad litem is doing their thing, right? You've given your information, attorney ad litem's got to go do their investigation. What do you do, right? Get your waivers signed by your heirs and file with the court if you've not done that already. Okay, so if you didn't initially file your waivers at the beginning, go ahead and start drafting your waivers, send them out to your potential heirs and say, hey guys, here's the waiver, sign, notarize it, return so we can file this with the court. Wait, just sit back and wait, but not forever, right? Reach out to your AAL if you think a long time has passed. I know clients get antsy, right? They're calling you constantly. I haven't heard, what's going on? And you're like, I haven't heard either, right? Just let them know that the AAL has to have time to do their job. Sit back and work on your other cases, right? Don't sit there twiddling your thumbs, be productive, do what you need to do. Follow up with your AAL if a long period of time has passed. And remind your clients, hey, this is what's going on and no news is good news. So, I just sent the information to the AAL 2 weeks ago, give them their chance to do their thing. They haven't called to complain. They haven't called to say I'm missing information. They must be doing their job. All right, get the phone call or the email from the ad litem that says, I'm done, I'm ready. And you're like, okay, what do we do now? Request a hearing date from the court for an heirship and or the administration. Okay, so if you filed separate documents and you want to do separate dates, heirship first, then your administration. If you want to do it all at once, reach out to the court and say, I'm ready to set my heirship administration matter. What dates do you have? Some courts you can call in person or email. Some courts you have to actually request it through their online portal. So familiarize yourself with your court, see what their policies and procedures are, see how they want you to request the hearing date that you need, all right? So as I mentioned, review the court's website to determine what their procedures are to request a hearing. Again, you can have them heard at the same time, or you can have them heard at different dates. Again, that's completely up to you. My recommendation is have it all heard at once. Get it just done and over and out of the way. Request several dates because remember, it's your calendar, it's your client's calendar, it's your witness's calendar, and it's your AAL calendar. So get with your AAL. One of the good things about the court's website, they will tell you what day of the week they like to hear certain matters. So if you go online and you hear, oh, heirships are heard on Wednesdays at 9 a.m., then go to your AAL and say, hey, this particular court hears dates, heirships on Wednesday at 9 a.m. What dates are good for you? Okay. Same thing with your clients. We're going to have a hearing date on a Wednesday. Which Wednesdays work for you? Same with your witnesses. Okay. If you're not particularly sure, get a couple of dates, email your AAL. Here's some dates that the court's available. Let me know what works for you. Same with the client, same with your witnesses. Okay, and then once you get a green light from everyone that this is a great date, then go ahead and set it on the court's docket. And again, follow the court's procedure on how they want that done. All right, so you got your court date, it's coming, you're ready to go, you're so excited. What do you need to do to get ready for your final hearing? Okay, for your heirship case, you're gonna want your judgment on heirship. So you prepare your judgment on heirship, you sign off on it, you send it to the attorney ad litem, the AAL signs off on it, then you're good to go. Now, really quick caveat, before pandemic, obviously all this was signed in court. You would bring your documents with you. I know towards the beginning of the pandemic, a lot of courts were wanting to get things filed online before your hearing date, but for other seasoned attorney, we're familiar of just bringing everything to court with this. Post-pandemic and via Zoom, a lot of the courts want these documents filed ahead of time. So in the court, again, the court's website will tell you what they want. So if they want ahead of time, get it all signed ahead of time. So prepare your judgment, you sign off on it, your AAL signs off on it, you file that with the court before your hearing date. Your 2 disinterested witness statements, okay? Some courts want you to have your witness statement signed and notarized and filed ahead of time. Some courts want you to file the proposed witness statements, not signed, not notarized, because it will be taken care of after your hearing. Again, the court's website will give you that information. Affidavit, certificate of service, and citation. This is what a lot of attorneys miss, and I'll be the first to admit, sometimes I forget to do this as well. You have to file with the court an affidavit / certificate of services citation. Affidavit means it's signed by your client. Certificate means it's signed by you. So I always file a certificate of services citation, and it's basically I, the attorney for the applicant, hereby swear or confirm that service of citation was done as follows. And they're paragraphs. So it will tell you, okay, did you serve people in person? Who are your heirs? And how did you get notice to them? So you would say, these were the following individuals that signed waiver of services. These are the individuals that I had to have served by certified mail, return receipt requested. These are the individuals I had to have served by personal service. The form is available through HVL. Literally, it's just type in the person's name, how they were served, and how did that get filed with the court? Was the return citation of service returned? Was the waiver filed? It's a really easy form, but a lot of people forget to do it. And then, of course, service on the heirs or waivers, if you've not already filed them. Make sure you have proper service on everybody or your waivers have, waivers have been filed. For independent administration, order of administration, signed off by you, okay? So make sure you have your order ready to go. You've signed off, you've approved it, ready to go. Your oath, signed by your applicant. Now, the courts wait for the applicant to sign the oath after your hearing. Some courts will ask that you send a proposed oath unsigned. Some just want you to wait after the hearing period. So check with your court. Proof of death and other facts signed by the applicant. Again, some courts want it ahead of time. Some courts want it after the hearing. And then once again, service or waivers of your heirs for your administration. Right, so if you've had them served or you need to get their waivers, go ahead and make sure that that's all filed and ready to go if not done already. All right, so prior to your hearing date, right, you filed your documents, you're ready to go, everything's been accepted. What do we do? Okay, make sure everything is filed with the court by their particular date. Some courts require the documents to be filed a week prior for hearing. Some courts within 72 hours. So verify, again, your court and how they want to have, when they want those documents filed, right? Your court is your friend, okay? The staff attorney will review your cases and documents ahead of your hearing date. And this is to ensure that everything was done properly, right? If something was not done wrong, you're gonna get a phone call from the staff attorney. And the staff attorney is gonna say, hey, this is your case, this is what's not been completed, we need to have this done. Some of this can be fixed before your hearing date, so you don't have to worry about a reset. Some of them will not. So for example, if you forgot your certificate of compliance, right, or your certificate of service, they're gonna call and tell you before you can have your hearing, you need to get the certificate of service on file. You file it, you're good to go. But if they tell you you forgot to post, because posting has to go for 14 days, you're gonna have to reset your hearing date, okay? So when the court calls you, just listen to what they tell you you need to get completed, get it done. If you can get it timely done before your hearing, you're great to go. If not, you're gonna have to reschedule. If you do not hear from the court, then no news is good news and you're good to go. Okay, and so as I mentioned, if you forgot to post, you'll need to reset your hearing. So who appears at the hearing, right? You got the green light, you're ready to go. You're going to do everything for your hearing. Who goes there? Okay. So the attorney, that's you. Obviously, you got to be there. The applicant, that's your client. Okay. So for an heir, and that's for both cases. For the heirship portion, the attorney ad litem. and your 2 witnesses. Now, obviously with Zoom hearings, it's my understanding that the probate courts in Harris County are going to be continue to offer those for uncontested matters. Your AAL is going to probably appear at their firm. Encourage your witnesses to come to your office, right? So it's going to be you, your client, and your 2 witnesses. If they're going to do it via Zoom, so that way you control the situation, you know for a fact they're there, the connection's working, everyone's present, you have your laptop, so all you have to do is rotate the laptop around the table so that you can appear. If your witnesses choose to appear remotely from their residence, just ensure that they are internet savvy and computer savvy and they know how to get online and appear via Zoom. Okay, and obviously the applicant and the attorney. Okay, for an administration, again, the applicant, you, the attorney, and most importantly, the judge, right? The judge has got to be there to have all this taken care of. Okay, so what evidence is presented at the hearings? Everyone's present. We're ready to go. Judge calls your docket. You know, you're nervous, but you got to go this first. Heirship has to be presented first, whether you do this as a combined hearing or separate. You got to do your heirship first because you got to have your heirs declared before your declared heirs can agree to your administration. So heirship presents first, right? You get the testimony of your 2 witnesses. So you call your first witness up, you have them testify, okay? This is typically elicited by you. They're your witnesses. You brought them to court. They're there for you, for your client. You elicit their testimony, okay? Use your statement, whatever statement that you prepared for your 2 disinterested witnesses, use that as your guide. That's going to help you with your questions and the information you need to elicit from your witnesses, okay? When you are done with one witness, pass your witness. Judge, I am done with this witness, pass your witness. Your AAL will come in, will ask whatever questions. If you elicited all your information, your AAL might just say, Judge, everything was covered, I have no questions. Or your attorney ad litem might just confirm some of the information. When witness number 1 is done, do the same thing with witness number 2. Call that second witness forward, have them identify themselves, ask them their questions. When you're done, pass that witness. Your attorney ad litem will ask the questions. When no other questions are needed, then that witness will be done and will be excused. Then the testimony of your applicant. So your 2 witnesses has testified, your AAL has cross-examined your witnesses, your applicant comes up, use your application as your guide for your questions, okay? Have your application there in front of you or have your questions ahead of time. If you're at Zoom, I typically try to type up the questions with the client and that way that they have their answers in front of them. You can do the same thing in court. That kind of looks a bit sillier, but it's possible. Okay, once you're done presenting your witnesses and the testimony, the court, you know, you let the court know, Judge, we're done. I have no other witnesses. I have no more testimony. The court will go back to the AAL and ask if they have any other witnesses or if they have any evidence to present. If everyone's done, then the court will make a ruling. And basically, you know, based on the evidence presented, I hereby declare that so-and-so, so-and-so, so are the heirs. This is their percent, and I'm signing your judgment on heirship.
We have 7 minutes left and I wanted 2 minutes, so 5-minute warning. Thank you.
Okay, thank you. Okay, so after the hearing is concluded, AAL gets excused, your witnesses get excused because they're not needed for the administration portion, if you decide to do the administration at that point, okay? So for the administration, I'm going to zoom a little bit here. Applicant's testimony, again, use your guide, your application as a guide. If you have any other witnesses or parties that may appear and that you have requested to be present, you can have them elicit. Most times on an administration, it's just going to be you and your applicant, nobody else. Once everyone's testified and evidence presented, judge will make the ruling, will sign the order granting letters of administration. Okay, client will sign the oath and proof of death and other facts. Check with your court. Sometimes it's after the fact, sometimes it's before your hearing. Check with your court. Okay, client's appointed as administrator. What do? Client signs the oath. You file that with the court. You request your letters of administration. Okay, letters is $2 a letter for your administration. Minimum, I order 5 letters because you're going to need a letter for a bank account, You might need a letter for a title company. You, the attorney, is going to need a letter that you can just scan and keep a copy in your electronic database. And some other institutions might require letters. So talk to your client, get an idea of how many letters you think you're going to need. I always, as a bare minimum, order 5. When your letters are received, depending on whether you need one or not, you're going to request an EIN from the IRS on the IRS website, right? You're going to need an EIN if you have to open up a financial institution account in the estate's name, because you're getting assets that have to be liquefied and transferred into an estate name. If this is strictly real property, you may not need an EIN depending on what you're going to do with the property. If you're going to transfer the property out of the estate's name into an individual's name via warranty deed or administrator's deed, you don't need an EIN. But if you're going to sell your real property under the administration, you're going to need an EIN to open up that administration bank account. Okay. You're going to need the client social security number for that, so please make sure you get that ahead of time. Once they receive letters and the EIN, and if they're required to open up, they can open up a bank account at whatever bank of their choosing for an estate account. Okay. Some banks may require a death certificate. After the account's open, administrator starts to collect and gather assets of the estate and deposit it into the estate account. So what do? Right? Give your notice to your beneficiaries under your administration. Whoever your heirs are, those are your beneficiaries. Send them notice of your client's appointment, even though that they've possibly signed a waiver. You still got to give them notice. Let them know of your client's appointment, what your client was appointed in what capacity, okay, and what they're going to be doing, which is gathering and starting to administer the estate. Affidavit, certificate of compliance. Once you send notice to your beneficiaries, you got to file this with the court to let the court know you've sent notice. Affidavit comes from your client, certificate comes from you. Right? Filed not later than 90 days after the order is appointed, admitting the will to probate. You got to send your notice to unsecured creditors. That's your publisher's notice to creditors that is submitted to the newspaper, daily court review. And as mentioned earlier, HVL clients get 50% off the normal cost to publish. Once that is returned, then you file the publisher's affidavit with the clerk's office. They will send that back to you and you have to get that. Notice to secured creditors, if there's a mortgage company on real estate or a lien on a vehicle, you got to send them direct notice. It's got to be done within 2 months of receiving your letters. You got to give them by certified mail return receipt requested. And you got to address it to the record holder of the claim. So the mortgage company, the vehicle lien holder, whatever that is, right? And then once your notice is given, you got to file with the court proof that you sent notice. Okay. Once you've done that, inventory and appraisement time. Okay. Work with your client on the inventory and appraisement and list of claims. This is a list of the assets and their value at the time of death. So people will say, okay, well, they died and 3 months later, this is the value. No. Value at the time of death. You got to file this with the court no later than the 90th day. So before the 91st day. So the deadline is 90 days from the date of appointment, unless you've asked for an extension from the court. You can do an affidavit in lieu of inventory and appraisement. Sometimes I do this if all I have is real estate, and I know this is not an HVL type situation. If I have tons and tons of assets, like millions of dollars, I'm not going to want to file an inventory and appraisement that lists the $1 million assets. I'm going to do an affidavit in lieu of. After that's been signed with the court, so you submit it with the court, it's filed, the court signs and approves it. Once it's been approved and everything's been met, the court will issue your drop order. Okay, if you don't see a drop order 10 days after your inventory has been approved, follow up with the court. Say, hey, we did this, what's missing? 9 times out of 10, it's your certificate of compliance. If you file your inventory and appraisement and you don't have a drop order, it's because you forgot to file your certificate of compliance. Okay, once it's dropped, then you work with the administrator to finalize the estate. You liquidate any remaining assets, you sell property, you liquidate stock, you get retirement money, whatever the case it is, deposit it into the estate account if that applies. Determine whether any estate taxes are owed. Again, with an HVL case, this will probably more likely not be the case. Pay any debts or creditor claims that are due and owing in the order of priority. So if somebody submitted a claim with the court, or you've gotten a notice from DCM Services that they had an American Express card with $500, go ahead and start paying off the debt in the order of priority, provided there are funds to do so in the estate, right? And then you distribute the estate to the heirs that were determined by the court and their respective percentages. So this is where you go back to your heirship to say, okay, here are my heirs, here's their percentages of what they're entitled to. That's how you distribute the estate, right? You obtain receipts and releases from the heirs when they receive their property, okay? Other than the representatives. So, brother, sister, whoever, you send them a check for $10,000, they write you a receipt and release acknowledging the $10,000 and that they're releasing the estate from any and all future possible obligations. When you've done all that, you close out the estate. That's it. You get with your client. I know HVL has a portal that you have to go in there to close out with them. And I'm understanding that they'll provide that information when they assign you a case. But you ensure that everything's taken care of. If it's a regular one-person heir, like a spouse or sibling, and it's not an issue, the drop order is sufficient. Many attorneys will go ahead and do a formal closing. I do that when I had a contested matter. If I'm going to have an estate that's a contested matter, an heirship that's contested, I will do a formal closing by sending a formal closing letter to the clerk's office. 9 times out of 10, a drop order is sufficient for me. Okay, I know I answered some questions. I'm not quite sure how I'm doing on time.
We're out of time,
Okay.
but if you don't mind going forward,
Yes.
one slide, I just want to do my slides,
Okay,
please. And then I have 3 questions for anyone who wants to hang out.
Okay, so there's my information, there's the CLE information, and these are Miss Lisa's slides.
So in addition to taking probate cases, we hope that everyone will also consider taking a guardianship case. We have a medical legal partnership with Texas Children's Hospital, and most of our guardianship cases are for children who are turning 18 and are becoming adults who still need, ongoing medical care and maybe don't have the capacity to do that themselves. And so there's a great need for parents to become guardians, and that's also done in probate court. So it's a really, really rewarding experience because you're helping parents care for their disabled children. Next. They're uncontested. We only take uncontested guardianships. So it makes it very form-based and very formulaic. It's a friendly court. Vanessa said several times that probate court is friendly. Guardianships are in probate court. It is still a friendly venue. And the staff attorneys are helpful. The courts are helpful. It's just a pleasant place to be, quite honestly. We provide mentorship. Our medical legal partnership staff attorneys will mentor you and provide templates or the forms, because it is forms-based, and you get great skills and experience. In order to take a guardianship case, you are required to take a 4-hour CLE. I think that CLE costs about $200. If you take an HVL guardianship case, we give you that CLE for free, and then you can take other guardianship cases. You do have to take that annually. I don't remember if it's
every 2. Well, it used to be every 2. I think they upped it to every 4 now.
4 years. It's more than 1 year. Okay. You have to. So if yours is expired and you would like to take an HVL guardianship case and get that CLE for free, go ahead and contact Stephanie Summerlatte. I will. We'll send out her contact information when we send out the slides as well. Next.
Oh, there we go.
I want to encourage everyone to take an HVL case, whether it's probate. I hope everyone feels more experienced with this. We will have another CLE next week talking about small estate affidavits and affidavits of heirship, which is a much simpler process than what Vanessa went over today. Thank you. We had a CLE last week that's recorded on probating a will and probating wills, unmemo titles. If you have specific questions, please feel free to reach out to our pro bono coordinators. They will, if you have a specific interest in any type of case, they will help you find the case that fits your interest. And we have forms and guidance. There were, for anyone who wants to stick around, I held off on 3 questions. The first one is, if someone has temporarily moved to Harris County from a surrounding county and dies in Harris County, but has real property in another county, where would the estate be probated or administered?
So it's typically done in order of priority. You can do it in the county that the decedent died in. That's the first priority. If, for example, decedent doesn't, let's say decedent moved out of state and there's real estate here, you can do it where the decedent had their primary property located. So you can, if they die in Harris County, you can probate in Harris County, and it doesn't affect where the real property is located.
Is it permissive? Can you choose which county, or do you have to do it in the order of priority?
I think it's permissive. It's been a long time since I've had to do that, but I believe it's permissive. So
I'm
obviously I'm not going to want to do something out of state. If I can put it here, I will.
I'm pretty sure it's permissive as well. Okay, the next question is, if there is a contest regarding the heirship, for example, a common law spouse pops up after the attorney ad litem completes the process, it said, the question is, it needs to be heard by a judge to determine the validity of the common law marriage, correct? I'm going to say
Yeah.
that is correct. And is there, do you know what the statute of limitations is to contest that? Sorry, I'm adding a question.
No, that's okay. So a party has 2 years from when an estate is opened to file a contest. Um, so if you have a determination of heirship and then you file your administration, whoever wants to come in and contest it, they have 2 years from the opening of the estate to go ahead and come in and try to file a contest. It's most of the time it's not, if you're going to have a contest of a common law spouse, you're going to know right up front, because 95% of the time, the common law spouse is the one that fills out the funeral, the obituary information, and they list themselves as the spouse. You rarely ever have a situation where a child might come in and then the common law spouse waits a year or year and a half to come forward. They're going to make their presence known up front very quickly.
Also, when we're asking who the decedent lived with, just so you know. And if they're living with a romantic partner, we'll ask if they were married. And just so you know, and I know that maybe the children don't think they're married, but we do try to follow up with that. There is another question. I will repost the CLE number in just 1 second as soon as I give this last question. If you do a determination of heirship without an administration, do you do the other matters? I'm going to just go ahead and say no, you only do the determination of heirship portion. And sometimes you don't need to do an administration, you only need the determination of heirship.
Right. And my understanding from Lisa is that the HVL will determine that for you. They will determine whether it's an heirship only or an heirship. You can do an heirship without an administration. You cannot do an administration without an heirship if it's intestate, if that makes sense.
Because you have to know who the heirs are. In a will, you name who's getting your property.
Correct.
When you die intestate, the court gets to determine who's receiving the property.
Right, because you can, like I mentioned earlier, you can have a will that says to my spouse dies, then to my heirs at law. Well, okay, I don't need an administration. I have a last will and testament. I have an executor. I just don't know who the heirs are. So you do an heirship portion of it. Or again, as I mentioned, the trust. You have a trust, same situation. You don't need an administration. You just need to figure out who your heirs are. So if you just strictly do an heirship, then you don't need to do an administration because you have other avenues that will help you get where you need to get.
And as Vanessa said, we do screen cases. We do make a recommendation as to what we think the best course of action is. If you discover something different or you think we haven't recommended the best course of action, then it's your case and you're the attorney. You can do it however you like, or you can call us to discuss. We are over. We're past 1 o'clock. If anyone else has any questions, I can stick around to answer general questions. I don't know what your schedule is, Vanessa.
I'm available. I went ahead and put up the my contact information again, and
thank you.
So that's there, and the CLE information as well. And I'm available if somebody has questions. Then we can. I'm here to ask.
Well, then I don't see any more. So I'm going to go ahead and stop the recording. My favorite slide transition, by the way, was the paper airplane one. If that was your son's.
That was my son. So anything that was jazziest, like the origami or what, that was my son's.